And welcome to a Law Talk with 12 Old Square Chambers. I'm Aaron Wahid, a member of the Immigration and Human Rights team. Today I have with me Mr. Shardov Karim, a noted practitioner in the area and also a member of our chambers. Hello, Shah.
Hello, Aaron.
At the outset, please be reminded that everything we discuss is correct as of today's date, which is the 28th of January 2021. Also, this isn't formal legal advice, but merely a legal discussion about topics of interest. Shardov, today we're going to talk about the English language testing scandal, also known as the ETS scandal. Could you provide some background as to that for us, please?
Thank you, Aaron. So I think most of our the legal fraternity know that there was the BBC Panorama program back in 2014, which unearthed a scandal of sorts, which involved the English language testing system, ETS or TOEIC. This is where a number of individuals were allegedly involved in using proxies to undertake these tests, which were at the time approved by the Home Office. And of course, following on from that BBC Panorama program, the Home Office took enforcement action against a number of individuals, thousands in fact, people who were here as students and other points-based migrants and individuals, taking enforcement action, curtailing or cancelling their leave and bringing an end to their lawful presence in this country, based on these allegations that these individuals had used proxies to successfully take these English tests. So that's a bit of background as to what happened with this scandal.
Shardov, this inevitably generated a lot of litigation. What are the main cases that arose and what did they say?
So Aaron, as you're aware, this is an area which has been quite heavily litigated. There are a number of authorities, and I could spend a day going through all of them, but I think given time and given the fact that we need to keep this as simple and clear as possible, three authorities come to mind. The first is the original test case, that's the case of SM and Kadir, which 12 Old Square were involved with. And that's the case which essentially looked through the evidence as it stood then, and it set out the three-stage process that is to be employed in these types of cases, namely that the evidential burden is initially in the Home Office, that if that is discharged, there is a burden on the appellant or applicant, which is simply to provide an innocent explanation of the minimum level of plausibility. And if that is done, then there's a further transfer of the burden, and it falls on the Secretary of State to discharge the legal burden. The second case which comes to mind is from late 2017, the case of Arsan. And again, 12 Old Square were involved in that case as well. And that case confirmed and essentially was unprecedented in that it explained that the out-of-country remedy, which up until then was found to be suitable and adequate, was in fact not adequate in these types of cases where oral evidence was extremely important. So Arsan essentially confirmed, as I said, that there is a need for in-country hearings to determine these matters. And the final authority which comes to mind in this area of law is the case of Khan from 2018. Again, 12 Old Square were involved in that one as well. And that case was quite revolutionary in that it confirmed that the human rights appeals process would be the correct vehicle through which the allegation of deception, in this case, the ETS allegation, would be resolved. And if the individual is successful, then following on from Arsan, they should be put back into the position that they would have been in prior to the ETS decision initially being taken.
Thank you, Shardov. Could I also ask, do you have any general tips for applications and if they fail, appeals from those?
Yeah, so as you've already pointed out, Aaron, this isn't designed to be any formal legal advice, and I'll reiterate that any individual concerned should seek the appropriate legal advice. But just generically, what I would say is that it's very important, whether it's an application or an appeal, that as much information and evidence is obtained and produced as possible, So I always say that there should be a very detailed witness statement from the individual concerned explaining precisely the information that they can recall, such as where they took the test, how they got there, etc., etc. I also say that it's important to try and get any corroboration if possible. So that could be, for example, someone who accompanied you to the test, a statement from them, or a friend or someone you spoke to after the test, confirming that they had the conversation with you following on from the test, or some evidence of travel, such as a ticket or bank statement showing payment made to the test center. I also say that in most cases, there should be a request for the actual audio files from ETS themselves, and certainly ETS should be contacted to try and ascertain what has happened. Beyond that, I would say try and gather as much correspondence or literature you can from the test center and anything else which shows that you were at the test center and that you took the test. Evidence of your academic abilities, your English language abilities, certificates, previous tests, any mock tests, any mock papers, any letters from tutors, anything of that nature usually is very handy and useful in these types of cases.
Thank you very much, Sean. I would also say that I agree with your point that this isn't formal legal advice. And of course, people listening should seek professional legal advice as to their own particular circumstances. Now, Shardov, I wonder if you could kindly tell us what would happen or what you should expect to happen were your appeal to be allowed in respect of an ETS case.
That's a very good question, Aram, and one that I'm asked quite regularly. Look, these cases are all case specific or fact specific. There isn't a one size fits all approach to all of them. But generally, if there is a historic ETS decision and on appeal, if the individual is able to show that they were not involved in any proxy test taking or any deception, or put another way, if they're able to show that the Secretary of State hasn't been able to discharge the burden, then one should expect to be put back into the position that they were in, but for the original ETS decision. So that means that usually the Home Office considers them as someone who hasn't overstayed, treats them as someone who has 3C leave, and gives them some period of leave, anything from between 60 days to 6 months or even 2.5 years, so that they can regularize their position. But as I said, it isn't a one-size-fits-all approach. It depends on the individual facts and circumstances. But generally, if you win on appeal, you should find yourself in a pretty good position.
Thank you very much, Shardov. Thank you again as well for joining us for another of 12 Old Squares Law Talks. I hope that you found it useful and interesting, and we hope to see you again sometime. Thank you very much indeed.
Thank you.